Hi, I'm Sheila Holt,
And I'm Ashley Howell.
and this is our presentation on the Fifth Amendment. So, the Fifth Amendment is an amendment to the United States Constitution. And in the Constitution, it reads as no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service, in time of war, or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So, in simpler terms, what that actually means is the Fifth Amendment is an amendment to the Constitution that guarantees U.S. citizens specific rights, including not having to testify against yourself if you are accused of committing a crime. The Fifth Amendment protects people from being put in double jeopardy, meaning they cannot be punished more than once for the same criminal act, and that once found innocent of a crime, they cannot be prosecuted again for the same crime. It provides that no person shall be compelled to serve as a witness against himself, or be subject to trial for the same offense twice, or be deprived of life, liberty, or property without due process of law. It allows you to refuse to answer questions during a criminal trial to avoid accidentally confessing to the crime. This is also known as plead the fifth.
Guaranteed Constitution rights in the Fifth Amendment. Grand juries for capital crimes, protection against double jeopardy, protection against required self-incrimination, guarantee of a fair trial due process. Due process is a long-standing American tradition. Its worth is so valued that it is the only command of the United States Constitution that is specifically mentioned twice, in the Fifth Amendment and in the 14th Amendment. A guarantee that the government will not seize private property without paying market value. Why is the Fifth Amendment important to educators? Schools, colleges, and universities across the United States grow and evolve daily to become more multicultural, diverse, and inclusive. One of the many tasks of educational leaders is to constantly create and nourish an empowering school culture. For educational leaders, it is critical to constantly reevaluate policies and procedures to ensure that all students, regardless of race, gender, sexuality, socioeconomic level, religion, or exceptionality, are given the proper tools to succeed and not provided with a pathway to poverty or prison. For educational leaders, knowledge and understanding of due process rights in relation to both amendments is important because no disciplinary process can start without a student, faculty member, or staff personnel understanding his or her rights and being given due process to establish his or her innocence.
So, what do educators need to know about the Fifth Amendment? The United States Constitution does not deal directly with issues related to education. The Supreme Court and federal government still, however, serve as the final mediator of all legal cases brought on behalf of or against schools, colleges, universities, and or their governing boards and stakeholders. For educational leaders tasked with drafting policy and making tough decisions, it can be very difficult to understand, first, how perspective in the interpretation of law matters, and second, how certain decisions will affect their students and staff long term. Before any decisions can be made, educational leaders must first understand the rights of the students and staff and the legal parameters of power for both groups. They must be given their full due process. So that leads us into due process. Due process in education means that fairness should be rendered in all areas. and that a teacher's or student's rights as individuals should under no circumstances be violated. Due process is important because most court decisions regarding teachers, education, and ethical teaching pertain to the fundamental issue of fairness. All protections and rights pertaining to due process actually emerge from two amendments to the U.S. Constitution. The first one is the Fifth Amendment, which states that no person shall be deprived of life, liberty, or property without due process of law. The 14th Amendment, which asserts that the equal protection of the law should not be denied to any individual, and nor shall any state deprive any person of life, liberty, or property without due process of law. Typically, due process that is appropriated in the judging of the fairness of an action can be classified under two broad headings: substantive and procedural due process rights.
Substantive due process rights, which deals with the issue per se. Example, if a teacher was dismissed from his or her duties for treating a child in a particular manner that the child's parents were not pleased with, an issue of substantive due process is raised. The court's decision will be based on whether or not the teacher's actions fell within the lawful bounds of ethical teaching. The procedural due process. Procedural due process rights involve the circumstances and the manner in which the case was handled. Issues such as whether or not the teacher received a fair chance to present his or her side of the story in defense, and whether he or she was given an opportunity to question the evidence come into play here. Procedural due process is a broad term, and its meaning changes from state to state, depending on the region, specific laws, and regulations. The underlying idea behind practicing and attaching appropriate importance to procedural due process is to ensure that individual students, as well as teachers, are not unnecessarily burdened with arbitrary actions against them by any institution or individual.
So, minimum procedural safeguards for basic due process. First, the provision of an opportunity to be heard and the date and time for this opportunity should be provided to the concerned individual well ahead of time. A full, detailed account of the reasons for the proposed suspension must be furnished well in advance. The opportunity for the accused employee to defend him or herself and to question the evidence provided against him or her should be provided. He or she must, under no circumstances, be deprived of the opportunity to retain an attorney. The individual must receive the opportunity to cross-examine the witnesses present. It's compulsory that the decision reached must strictly rest on legal rules and laws and on the evidence presented at the hearing. The decision-making body must be impartial and unbiased. So, due process rights, policies, and procedures have become a topic of interest in special education, teacher tenure, and dismissal within recent years. For educational leaders, it is detrimental to understand all areas in which due process rights for students, faculty, and staff may be violated, and in what ways such violations are possible. By understanding the Fifth and 14th Amendments and how they have been used in relation to due process, educational leaders have a starting point for their decision-making as it pertains to the school, the legal system, policy, and procedure. Through a deeper understanding of due process, leaders will be better equipped with the skills and knowledge to draft sound, equitable, and equality-based policies and procedures that ensure fairness for all teachers, staff, and students in every way possible.
Here's the Miranda versus Arizona in 1966. This case has no relation to education, but it is the historical case that dealt with due process and is the reason we now have Miranda rights. Currently, because K through 12 administrators, faculty, and staff take on the role of surrogate parents, if students are under their care, schools reserve the right to determine students' rights to a certain extent. One of these rights includes those awarded by the Miranda versus Arizona decision. Although students are not specifically awarded all these rights, it is in the best interest of educational leaders to adopt aspects of them when drafting school policies and procedures dealing with the disciplinary decisions. The consideration of this case in policy development allows for a balanced approach to implementation that is fair and rational for all. This case represents the consolidation of 4 cases, in each of which the defendant confessed guilt after being subjected to a variety of interrogation techniques without being informed of his Fifth Amendment rights during an interrogation. On March 13, 1963, Ernesto Miranda was arrested in his house and brought to the police station, where he was questioned by police officers in connection with the kidnapping and rape. After 2 hours of interrogation, the police obtained a written confession from Miranda. The written confession was admitted into evidence at trial, despite the objection of the defense attorney and the fact that the police officers admitted that they had not advised Miranda of his rights to have an attorney present during the interrogation. The jury found Miranda guilty. On appeal, the Supreme Court of Arizona affirmed and held that Miranda's constitutional rights were not violated because he did not specifically request counsel. The Fifth Amendment requires that law enforcement officials advise suspects of their right to remain silent and to obtain an attorney during interrogations while in police custody. To protect the privilege, the court reasoned procedural safeguards were required. A defendant was required to be warned before questioning that he had the right to remain silent and that anything he said can be used against him in a court of law. A defendant was required to be told that he had the right to an attorney, and if he could not afford an attorney, one was to be appointed for him prior to any questioning if he so desired. After these warnings were given, a defendant could knowingly and intelligently waive these rights and agree to answer questions or make a statement. Evidence obtained as a result of interrogation was not to be used against a defendant at trial unless the prosecution demonstrated the warnings were given and knowingly and intelligently waived.
In Brown versus the Board of Education of Topeka, this is one of the earliest and most important cases in educational law, and specifically in relation to due process. This was a class action lawsuit that argued against the validity of separate but equal educational facilities. The plaintiffs sought the racial integration of schools throughout the country. The courts were deciding the question of does the separate but equal clause, as applied in Plessy versus Ferguson, also apply to public schools and public school students. The issue of racial segregation was so widespread across America that Brown was declared a class action lawsuit that comprised 4 separate but similar cases from Delaware, Kansas, South Carolina, and Virginia. The Supreme Court's final ruling was that segregation in education was unconstitutional and violated the 14th Amendment. They felt that separate but equal had no place in education because it has a detrimental effect on African American students and denied them the right of life, liberty, and property. In Julius W. Hobson versus Carl F. Hansen, in this case, the courts were debating the issue of if the District of Columbia school system complied with the desegregation order as detailed in Bowling versus Sharp in 1954, which ruled that Black students were deprived of their Fifth Amendment rights. The courts ruled that the District of Columbia did not do a good enough job following the desegregation order. An injunction against racial and economic discrimination was filed. The tracking system and optional zoning was abolished. Transportation for overcrowded schools was provided. A pupil assignment plan was to be created. Faculty were to be integrated, and a teacher assignment plan was to be created. The belief was and still is that racial segregation was detrimental to all students.
Peter Mills versus Board of Education of the District of Columbia in 1972. Another example of the Fifth Amendment usage of due process can be seen in the policies of the Individuals with Disabilities Education Act, which stems from Peter Mills Board of Education of the District of Columbia. This case was pertinent to the due process rights of Black students in the District of Columbia that were classified as having exceptionalities related to mental disability. The relief sought was the integration of schools and the admission of the defendants to certain schools as declared in the Brown and Bowling. However, this time the courts were debating the question of if the plaintiffs were denied their due process rights because they were classified as mentally disabled and or Black rather than self-identifying. In this case, Peter Mills, Dwayne Blackshire, George Liddell Jr., Stephen Gaston, Michael Williams, Janice King, and Jerome James were all Black students living in the District of Columbia. Each student was labeled as having a mental disability, which resulted in them being denied admission to a public school. Each student's family was poor and could not afford to send them to a private school. In the trial court, the school board agreed that school administrators were wrong for denying the students an education in the public school system. The administrators agreed to make adequate changes, but the changes were not satisfactory from the court's perspective. The court found that no student shall be excluded from a regular public education assignment because of a rule, policy, or practice of the Board of Education of the District of Columbia. Everyone involved with the case had to ensure that the enforcement of the court's decision. The District of Columbia was ordered to provide all school-age children with a free and suitable publicly supported education, regardless of the degree of the student's mental, physical, or emotional exceptionality. Additionally, they could not exclude a student because of a lack of resources. Students could not have been suspended for disciplinary reasons for longer than 2 days.
So, in summary, teachers and students do not shed their constitutional rights to freedom of speech or expression or other constitutional rights at the schoolhouse gate. Most of the laws, policies, and regulations that apply in your everyday life also apply in your role as a teacher. The school, however, is a special place with a unique mission. So the law protects and limits teachers and students, especially in public schools, a little differently. Educational administrators must understand the law to ensure everyone is held accountable and to protect the school, staff, and students.